requesting lesser included offenses?
Yes.
Okay.
I
Mis-
don't.
I'm sorry, I missed that. Yes by the state, no by the defense. Mr. Anderson, which lesser includeds?
I'm satisfied with the ones in the draft instructions, Judge.
Okay, so I want to make sure we're clear on the record here. You're requesting lesser includeds for count 1 to include second-degree intentional homicide, first-degree reckless homicide, second-degree reckless homicide.
Correct.
Then for counts 2, 3, 4, and 5, you're requesting lesser includeds for attempted second-degree homicide, for first-degree recklessly endangering safety, and second-degree recklessly endangering safety.
Correct.
Mr. Nelson, any comment?
We object.
Any basis?
The law and the facts. I mean, I don't want to try to be efficient here, but I don't think it's supported by the facts that have been presented here. Certainly as to, I understand count 1, second degree. We prefer not, but I don't think there's a basis in law or fact for me to make an argument that he doesn't get second degree intentional. As to count 1, first degree reckless, I don't think that there is a basis in fact that there is any evidence that it was utter disregard for human life in this situation where the person, Mr. Schumann, died instantly. So for those so we object to first degree reckless as to count 1. We're going to go through the other counts or just deal with count 1 first?
Now go through the other counts.
As to counts 2 through 5, again, I understand that second degree intentional is a lesser included of first degree intentional. So I'm not objecting to that. While we prefer that it not be offered, I agree that there's a factual and legal basis for it. As to the reckless endangerment, first degree reckless endangerment, again, there is no evidence that it was utter disregard. I believe in these cases, I do concede that the case law that I've seen supports the fact that reckless endangerment is a lesser included of attempted homicide.
Mr. Anderson.
So basically, both the state and defense are entitled to ask for a lesser included offense, and it's error for the court not to include lesser included offenses as long as there's a basis. So a jury could conclude that although he was reckless in stabbing these people, he didn't actually have the intent to kill them, hence the reckless charges. The self-defense is still at issue in all of them, but I think it's appropriate to have the lesser includeds.
My understanding of the law is that either party may make a request for lesser includeds. One party's decision to request lesser includeds cannot be challenged by the other party. So here the state is making the request. It's entitled to the instruction as long as the evidence supports it. In my judgment, the crimes that are being requested as lesser includeds are in fact all lesser included offenses. The homicides in count 1, the lesser degree of homicide certainly are. Same with the attempted homicides in counts 2 through 5. There's also a case law that says that the reckless conduct for each of the classes of offenses are lesser included. So I'm satisfied that the charges themselves are lesser included offenses. I'm also satisfied that the facts support the lesser included crimes that have been requested. I think Mr. Anderson's assessment is correct, that the jury could conclude that Mr. Mew did not have the intent to kill, but he did engage in reckless conduct by indiscriminately jabbing and swinging his knife around people. He testified today that he really didn't know what was going on, didn't know who was hitting him, didn't know where people were necessarily. It all happened very fast. Yet the knife was used in a way that would show utter disregard for human life. It was certainly reckless in nature. When considering utter disregard for human life, there are a number of factors to consider. What he was doing, why he was engaged in the conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. Again, we have a man who is using a knife in a dangerous way, indiscriminately brandishing it against others. Others were injured. Mr. Mew left the scene, left the wounded behind. After a delay, he tubed past them without rendering aid, without notifying police what happened. I think those are all facts that one could conclude are utter disregard for human life. So I'm satisfied that the facts support each